We are back, and we're having some pretty stimulating and exciting conversation, and it's practical. And we're talking a lot about being proactive in planning as we get older for a lot of different things. And during the break, one of the things, Susan, that you said that makes a lot of sense is when folks move here to retire from different states, do they need to go to someone like Jay and have new paperwork drawn up? How does all that work?
Well, absolutely, they should have somebody review their documents. Frequently, their documents are going to refer to the state they came from and wants to use that law. Well, it's not appropriate for them to be using the law from California and South Carolina because that's just going to make it more complicated to administer their estate later. What I tell people is their documents are effective here if they were effective and valid in the state they came from, but they won't necessarily turn out the same way they expected them to.
Okay, so my parents are here from Ohio, just a case example, right?
Sure, imagine that.
Imagine
Ohio.
that. I know, can you imagine that? All right, at what point do they need to change their documents? If they're here more than 6 months, if they're here permanently?
If they're residents of South Carolina, I always ask when folks call, are you a resident of South Carolina?
Okay.
And do you foresee that you're going to be here for the foreseeable future? If the answer to both of those questions are yes, then I'd say it's time to look at your documents. And the sooner, the better.
Right. Now, Jay, when you say how it plays out with the laws and so forth, like when it gets to a probate stage, that the way everything's executed? Or?
Well, even if they had a trust, it would be different in South Carolina than it would be in another state. You wouldn't want a trust being administered in South Carolina under California law, for example.
Okay.
Or Idaho or any other state for that matter. It's just going to be different. And there's going to be what we call conflicts of laws. So if some law in South Carolina conflicts with a law in the state you came from, that exacerbates the problem. And, you know, I am an attorney, but I don't want people to have to hire extra attorneys when they administer their estate. Do you want to really hire an attorney from Ohio and an attorney from South Carolina to administer your estate in South Carolina because your documents refer to Ohio law?
Can you give us just a little example of what one of those conflicts of interest would look like? In other words, what's something that maybe is in Ohio that's not in South Carolina or in California that's not here?
Let me bring it back to Susan just a minute with something she brought up on the healthcare powers of attorney, for example. South Carolina has a very specific healthcare power of attorney form that the legislature actually drafted. It's not a document I put together, it's one they put together. It's specific to South Carolina. The nice thing about that is South Carolina courts and hospitals and physicians have looked at that document and it's been interpreted over and over again.
Got it.
They don't have to seek out, what does this mean? And as you can imagine, South Carolina and, for example, Washington State or Oregon, there's a difference with pro-life and pro-choice decisions from the legislature's perspective. Well, guess what? That's going to impact Susan's business when they're bringing in a document from Oregon or Washington State in South Carolina, a pro-life state. They may think, wait just a minute, I'm not sure this is going to be interpreted the same way here in South Carolina as it would be in another state.
I never thought
we
about
better fill out the South Carolina form if we want it to work out with a lot less litigation.
As a slight segue, does that go for your business and your business too with being proactive? You know, you talked about safety plans and before an emergency happens, right at home. I mean, sort of get your ducks in a row. Chicken, egg, which, yeah, right.
I'm not sure which one I want to be.
Right, exactly. Yeah.
That's what day it is, right?
Right, exactly. Well, and that's probably true.
Right.
What do you all recommend your clients do to be proactive in planning for, you hate to say planning for the worst, but it's the truth.
Well, I think anytime we're introduced to a family, be it in a crisis situation or they're being very proactive, we can get in and actually start talking to them. And because of the education we can offer, we go to the table with that, and that really helps them, and that kind of gets them to move in the right direction, if you will, and call the experts. Thank goodness we have attorneys.
Right,
I
exactly.
get so lost in all that, you know.
Yeah, we do, as part of our assessment when we go in to speak to somebody for the first time, we talk about a lot of different things, and one of the things are legal aspects, and we try to make sure that they have these documents. As I mentioned, it is not unusual to find that somebody doesn't even have a durable power of attorney or a healthcare power of attorney. If they have them, we like to make sure that they are updated, that they, you know, they will work, and We also have them for our purposes, if we are going to be representing them in a hospital situation with physicians, we have them sign release forms that will allow us as care managers
Oh, I
to,
never even thought about
to
that. That
act
makes-
for them. If they're in an emergency room, we get these documents, these authorizations signed. We get forms signed that would allow us to talk to family members. You know,
Oh,
you do that when you go to a
yes,
doctor's
exactly.
appointment. You have to say who you will allow them to talk to. We do the same thing so that if there's an emergency, we can call the daughter in California, the son in Portland, Oregon.
We're going to take a break. We're talking about things that really can make senior living a very positive experience. Stay with us. We'll be right back.